My dear friends, I am taking a very important question of second paper whose code is K5002. What is the question? Provision of cr.p.c under which a wife can get maintenance from her husband. This is a very important question, and first of all, I will define who can claim maintenance. Under section 125 to 128. Under this section, wife, minor child, mother and father can claim for maintenance. Second, according to section 125(1), this section may order for maintenance for wives, children, and parents to any person having sufficient means. Under this section, judge may order for maintenance for wives, children, and parents. What is the condition? Condition is that any person having sufficient means. This is the condition. So, the definition of wife, children, and father and mother. First, A. His wife unable to maintain herself. This is the condition. Second, B. His legitimate or illegitimate minor child. This is also very important. Legitimate or illegitimate, both comes under this section. C. His father and mother, both, unable to maintain himself or herself. These three types, or you can say these three categories, in which wife, children, and mother and father comes, if they are unable to maintain their self, they can get maintenance from wife from her husband, children from his father, and mother and father from his son. So now I am taking next step. My dear friends, now come to the condition when husband neglects for maintenance. Under section 1251, if he neglects or refuses to maintain, then a magistrate of the first class may, upon proof of such neglect or refusal, order such person to make a monthly allowance for the maintenance of his wife, not exceeding 500 rupees in the whole, as such magistrate thinks fit, and to pay the same to such person as the magistrate from time to time direct. Now, explanation of wife. So, wife includes a woman who has been divorced. First condition, who has been divorced by her husband, or who has obtained a divorce herself from her husband and has not remarried. There are three conditions to get maintenance. Who has been divorced by her husband, and who has obtained a divorce from her husband, and has not remade. This is the third condition. Now, second point, such allowance shall be payable from the date. From which date the allowance will be payable to her? From the date of order by the magistrate or from the date of application for the maintenance. There are two dates, either the date of the order or from the date of the application for maintenance. Next, my dear friend, third condition. If any person so ordered fail without sufficient cause to comply with the order, any such magistrate may from the every breach of order issue a warrant for levying the amount due in the manner provided for levying fines and may sentence such person for the whole or any part of each month's allowance remaining unpaid after execution of the warrant to imprisonment for a term which may extend it to 1 month. My dear friends, these are the conditions. If he fails to pay the maintenance, the magistrate can take action which is mentioned in this paragraph. Extend it to 1 month or until payment of, if sooner made. Condition, provided that no warrant shall be issued for the recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it becomes due. My dear friends, in third paragraph, these are the conditions for payment, and if he fails to pay, then what the judge take action. This is also mentioned in this paragraph. Now I'm taking next fourth. My dear friends, next, provided further that if such person offers to maintain his wife on the condition of her living with him, and if she refuses to live with him, this is the condition made by the husband. And if she refuses to live with him, such magistrate may consider any grounds of refusal. Here, the magistrate has to find out the grounds of her refusal stated by her and may make an order under this section in spite of such offer if he is satisfied that there is just ground for doing so. Explanation, if a husband has contracted marriage with another woman, this is first condition, or keeps a mistress, this is the second, it shall be considered to be just ground for his wife's refusal to live with him. There may be two conditions, and it is to be noted that under section 125 to 128 of the code make provision for maintenance of his wife. This section provides the provision for maintenance of his wife, and it is the duty of her husband. It is the natural and fundamental duty of every person. According to this section, it is the natural and fundamental duty of every person to maintain his wife. So, my dear friends, these are the conditions, and according to these conditions, judge may order as he thinks fit. Next, my dear friends, next, the provision of the code chapter give effect to this natural duty of a man. Express, it is the natural duty of a man to make. These provisions serve a special purpose to avoid. There are they are enacted with the object of enabling this. Next, provision of this chapter apply whatever personal law. Here you see, this is the important point, my dear friends. What this chapter says, the provision of this chapter, personal law, whatever may be the personal law by which the party in some religion, in or you can say in one religion, personal law. However, in order that a wife can claim against of that, a wife can claim under this section, it must be proved that she was a legally wedded wife applicable to the parties. The personal law helps in expressing that she was a legally married. She was a legally wedded wife under this personal law. After this act act as, my dear friends, I am giving you a very good example section in Mohammad Ahmad Begum 1985. This example you know very well. When this decision came by the Supreme Court, this decision made a hue and cry in the Supreme Court held that Supreme Court held that under section 125 was applicable of the religion clause B of 125(1). Limitation so as to justify exclusion of Muslim women. My dear, women cannot be excluded from this section, and Muslim women. And example of this benefit is given here. Case in Muhammad Ahmad Khan versus Sahabano Begum. In 19, a very important decision was made by the Supreme Court in favor of the Sahabano Begum. Now I am taking, my dear friends, I have mentioned the example of Muhammad Ahmad Khan versus Sahabano. In that case, Supreme decided or Supreme gave a revolutionary judgment. And due to that judgment, there had been a lot of hue and cry by the Muslim fundamentalists after this revolutionary judgment of the Supreme Court, which was truly intended to protect the interest of the Muslim women from the oppression. My dear friend, in this example, in this case, Sahabano got success in getting maintenance from Muhammad Ahmad Khan, rupees 500 per month. Now, what happened after this? Consequently, the central government was compelled to bring a legislation nullifying the judgment of the Supreme Court. Therefore, Parliament passed a Muslim Women's Protection of Right on Divorce Act in 1986, providing for other remedies to the Muslim women. This new act allows a Muslim woman to avail the remedy available under section 125 cr.p.c only if the husband consent to it. My dear friends, this new act was passed. In this act, there was some change that in this act there was a condition: the woman can get the maintenance if the husband consent to it, or husband consent to the divorce, or consent to the divorce taken by her. So the result was that in Muhammad, now this new act was passed, and after passing this act by the parliament, what happened? A case came to the Supreme Court. The result was that in this case, in Muhammad Umar Khan, this was the case Muhammad Umar Khan versus Gulshan Begum in 1992. The claim for maintenance by wife under section 125 was not maintainable because there was no declaration by the husband under section 5 of the Muslim Women Protection of Right on Divorce Act 1986, consenting to be governed by section 125 to 128 of the CRPC code. My dear friend, all these codes were applied, but there was a restriction of this code, a new code which was passed by the parliament, Protection of Rights on Divorce Act 1986. In this act, there was a condition, there was a clause: if the husband consents to it, then it is possible. So, in Muhammad Umar Khan versus Gulshan Begum, 1992, she applied for maintenance in the Supreme Court, but she failed to get the maintenance due to this new act. So, my dear friends, this is a very important question, and in this question, I have given two examples to you. One, Ahmad Mohammad Khan versus Sahabano. In this case, Sahabano got maintenance by the Supreme Court, rupees 500. But after the Muslim fundamental made a hue and cry in the whole country, then Parliament was forced to pass a new bill. Then Parliament passed a new bill, Protection of Right on Divorce Act in 1986. According to this bill, a clause was introduced in this bill only if the husband consent to it. Then a case came to the Supreme Court before the Supreme Court of Muhammad Umar Khan versus Gulshan Begum in 1992. In this case, she fails to get she failed to get maintenance from her husband because according to this new act, the husband did not consent to it. So she failed to get the maintenance. My dear friends, this is a very important question. I have said many times to you. So, with examples, I have tried to make this question or maintenance of allowances, maintenance of wife by the husband. So, in the end, my dear friends, I want to make a request to you. Please subscribe the channel. I shall be very thankful to you.